Constitutional Court has ruled that the Electoral Act is unconstitutional. Now, this opens the door for independent candidates to stand for elections without any affiliation to a political party. The application challenging the constitutionality of the Act was brought by NGO, the New Nation Movement. Tshego Motaung is the New Nation Movement spokesperson, and she joins us now on the line. First of all, congratulations to you, Tshego. How are you and the rest of your members feeling right now?
Oh, Tammy, we are so happy, we are excited, and this is not just for New Nation Movement, but it's for all of us. It's a victory for every South African. So we're very excited. We are just, it's just that we're having to deal with the lockdown restrictions, but we would be having a party right now.
Now, we've been hearing as well from the First Nation movement, the First Nation people. What is the relationship that exists between you and perhaps other stakeholders that were part of this application?
So what happened, Tammy, this has been a journey. I think a number of, the case was initially initiated by Dr. Michael Louis and a couple of other organizations, including Book Africa and individuals. So the Constitutional Court moved it out because it needed to go first to the lower court. And when it went to the lower court, the New Nation Movement, everyone rallied around the movement as a representation of all of the interests, in the case. So the First Nation Movement, because we recognize that everybody, we might come from different groupings, but we have the same interest as a nation. And with that vision of seeing a new South Africa, a new nation, every one of the different groupings came behind it, and that's how we even connected with the First Nation movement. So we couldn't list all the people that were actually participants in this case, but it actually represents the majority of the people of South Africa that we've encountered over the time.
And what were the reasons for actually taking this to the courts? What is it that you ultimately wanted to see changed? What is it that you were dissatisfied about?
Sure, Tammy. I think one of the, a turning point also in the life of our history was when, if we remember, there were motions of no confidence that were passed in Parliament. And we saw that even though members of Parliament that were within the ruling party wanted to pass those, to vote for, that they were in a way told that you will not do it. So that exposed the weakness in our system to say, so does that mean when I am now a member of Parliament, I can no longer, one, we vote for you, Tammy, because we trust you, we've seen you, how you've served South Africa, we believe in you, and then, but we bring you into a political party, and when you get there, we say, no, Tammy, listen, all of those things that you represent, we are not going to talk now, you are going to toe the party line. I think that was the biggest exposition of the weakness in our electoral system, and we've seen it also. I think the first round was when President Beki was removed. Many people who were not ANC members voted for the ANC because of the president. But when he was removed, they were not called to a meeting to be asked, are they happy with that? The same happened in the Western Cape. Patricia de Lille was removed, and yet the people who voted for the party. So that's when you start seeing there's a big gap between the voter and the political party. And once the voters have voted, they no longer have a say, and political party bosses run the show, and we're dealing with state capture as a result of that.
Take us through the points of unconstitutionality that were outlined by the judge today.
Okay, so we still going through this case, as you can imagine, Tammy, going through the excitement of what we've just gone through, but one of the things by not allowing people to participate and forcing them through to join the party. It's a limitation, and therefore it is a limitation to their constitutional right, and it conflicts, with the other section that allows. So that's one of the things that that was raised, and just. Yeah, so that is one of the things. And another issue that is there is that also this matter has been brought forward through the electoral task team that was set up in 2000. So the loophole had been recognized prior, but because at the time, as you remember, we were coming out of a season where people didn't even know the leaders because of the political party that had been banned. So the constituency system could not be applied because people were in exile, etc., etc., etc. So I think they literally responded to that prayer to say we need to be in a position to elect from our constituency, and people they must exercise their freedom if they want to participate in political process, being part of a party or not being part of it. And that was, as far as that it limits that was the issue that was declared unconstitutional.
So now that the ruling has been made, what role are you, as well as the other stakeholders, going to play in perhaps monitoring the process from henceforth? Political parties or Parliament has been given 24 months in order to see how they can fit this in now into the electoral process. But where to now for you?
So one of the things we began doing even last year, we had dialogues we engaged with professors from that university, and we had different stakeholders, which included members of political parties too, because what we understood is that changing the law to allow independent candidates alone is not going to resolve the weakness of our electoral system. That we need to apply reforms that are wider, and therefore this was one of the initiating tools in a way to get the conversation out there, because people were not even aware of the limitation that we are faced with. We understood, we are frustrated with this, but we didn't know how. So as you'd recall, there's also the judgment of My Vote Counts that spoke around the issue of funding. But now we recognize that the conversation has to now look holistically also in terms of where we are as a nation. How do we then reconcile some of how do we maintain our proportionality and ensure that there's accountability and all of that, and put it in a way that ordinary South Africans can understand. So what is going to happen? I think all of us who were there, we agree that we need to begin, the work begins to mobilize the nation now to begin to say, how do we move forward and not leave this matter to Parliament? Bearing in mind, Parliament had the Slavat report earlier in 2002, and the president, former President Kgalema Motlanthe, made recommendations. So Parliament has not been eager to make these changes. So it is a responsibility of South Africans to educate themselves and get involved in ensuring that in their communities they begin to identify and elect leaders and find ways of holding them accountable. So there's no one solution, but it's a beginning of a journey, I think, that will usher new leadership in the nation, a fresh breed of people who care and love this country and will put the interests of the country above the interests of their political parties.
Well, thank you so much, Tshego, for your time this afternoon. That's Tshego Motaung from the New Nation movement. They were one of the stakeholders who presented this to the Constitutional Court and have now really gotten a positive ruling. The Electoral Act as it exists found to be unconstitutional. And a couple of things that the judge spoke about, Judge Madlanga. He said that not joining or forming a political party was as much of a political choice as not joining one. So basically saying that the idea of a free self and one's idea of freedom was being stifled by feeling that you had to join a political party in order to be of national service or to serve your community.